Yes.
Thank you, my Lord. My Lord, if I can begin just by dealing with one of the questions, which I said I would come back to. Your Lordship asked me about the amount of the restructuring surplus. If Your Lordship goes to the supplemental bundle, divided to page 113, there is a table. Figure 1. If Your Lordship looks at the first column of figures...
That's the BCG
Yeah,
figures.
exactly. So that essentially summarises the plan company's figures, which are the BCG figures. So under the restructuring plan, there's total gross proceeds of 7,119 versus the relevant alternative total gross proceeds of 5,354. And that difference is 1,765, so about 1.7, 1.8 billion euros. Just for Your Lordship's note, of the 7,119 under the plan, on BCG's figures, that would pay the notes in full, as you see. But in addition, they were projecting 309 million euros to go to the shareholders. So that's the restructuring surplus. The short answer is on those figures, it's 1.765 billion euros.
Thank you very much.
So, my Lord, to go back to where I was before the short adjournment, I was just dealing with ground 1. We've just been looking at the amicus case. In relation to that, there's essentially 2 submissions to make. I mean, either it's to be read in the way suggested by my Lord Justice Snowden, in which case it doesn't, in our submission, provide any support for the way the judge relied on it in dealing with the issues in relation to the different treatment of the sons per se in the present case, or alternatively, to the extent the judge was simply transplanting over the Telewest principles to the context of class cramdown more generally, then we submit that that was wrong for the reasons I've explained. Just dealing, whilst we're here, with one of the other first instance authorities. Since the first instance judgment in the present case, there has been another first instance case which has taken a different view to the judge on this point. And that's the decision of Mr. Justice Adam Johnson in a case called Great Annual Savings. Your Lordships will have that behind divider 39, which I think is in Authorities Bundle 3 for Your Lordships. And again, this is a restructuring plan case under Part 26A. It was a case where, in fact, the judge refused to sanction the plan, essentially because of the way in which HMRC was proposed to be treated under the plan. But he dealt with the approach to the question of fairness more generally in paragraph 98 onwards, which is at page 1189. And you can see what he said at paragraph 898. He said, fairness, this is the main area of dispute. All the objectors maintain that the plan operates unfairly in relation to their interests. And then in scheme cases under Part 26, the concept of fairness has a particular role and is tested in a particular way. In short, a rationality test is used as a cross-check of fairness where there's been a majority vote in favour of a scheme by a particular class of creditor. And then he refers to Mr. Justice David Richardson, the Telewest case. And then paragraph 100, the present context, of course, is different. See Virgin Active at paragraph 222, where cramdown powers sought to be invoked, the relevant dissenting class will have voted against the plan, although other classes will have voted in favour. This is not a matter of imposing terms on a dissentient minority whose interests are materially the same as those of an assenting majority. It's a matter of imposing terms on the dissenting creditor class whose interests are different to those of the assenting creditor classes. And I think that has echoes of point which my Lord Justice Snowden was making earlier. And then he goes on. He makes the point in 101, strong overall support for a plan can nonetheless be an important discretionary factors, and if there are similarities between the positions of an assenting class and the dissenting class, the voting of the assenting class can help justify the conclusion that the dissenting class might rationally have supported the plan. And then he says in 102 he doesn't think that helps in the present case. And the reason it doesn't help is essentially for the reason he gives in the very last sentence of 102, which is that HMRC has very different interests to the other creditor classes. And as he then says in 103, as the parties I think recognise, a more pertinent question to ask in such a case is whether the plan provides a fair distribution of the benefits generated by the restructuring between those classes who have agreed to it and those who have not, notwithstanding that their interests are different. If it does provide a fair distribution, that's likely to indicate that the negative vote of the dissenting class was not rationally motivated, which would support sanctioning the plan despite the assent. And the converse is also true. If it is not a fair distribution, that is likely to indicate that the dissenting class has voted rationally, and that would support the court refusing sanction. As to what might constitute a fair distribution, he refers to the academic articles from Dr. Mokal and Professor Patterson. And then 106, to address one of the points canvassed before me in argument, if the question to be addressed is one about the overall balance of fairness of the proposed plan in light of the relevant treatment of the different creditor classes, I fail to see why that should not involve comparing the plan with other possible alternative structures. Points of comparison might well be helpful. Indeed, in many cases, the basic challenge is likely to be, this is not fair. Things could and should have been done differently. As I read it, Zaccaroli said something, Mr. Justice Zaccaroli said something different in Rehoused.
Similar.
Quite right. Something similar in Rehoused. Because in addressing the question of fairness at paragraph 37, he posited an alternative plan structure in which the cram-down power sought to be used against the company's bank and not the other way around, as was the case under the plan in that case. And in our submission, those statements of Mr. Justice Adam Johnson are exactly right. We would adopt and endorse the analysis which he sets out there, which essentially reflects the submissions that we were making to the judge. One does need to look at how things might have been done differently when it comes to the question of deciding whether or not to exercise the cram-down power.
But I mean, what it shows is that all the jurisprudence about fairness in the context of schemes. I mean, you've got a lot of slightly differing statements as to what the judge sort of considerations be relevant to the judge. But I mean, what this judgment I think indicates is that very sensibly is that which of those principles is relevant to the particular case will obviously depend on the facts and circumstances of the individual scheme you're considering. I mean, it doesn't mean that the other principles are wrong.
Yes.
It's just that they don't have an application to the particular scheme that is under consideration.
Yes, I mean, we would respectfully agree with that, which is why, as I've said a number of times, that what matters are the facts of this case. And then the essential complaint which we make is that things in this case could easily have been done differently to achieve the same objective in a way that didn't prejudice us. And then the question is, well, is that a relevant consideration to take into account in deciding whether or not to exercise the cross-class cram-down power on the facts of this case? And we respectfully submit it must be. I mean, it's very difficult, we respectfully submit, to see how you exclude that as a relevant matter to take into consideration. And it obviously was a relevant matter on the facts of great annual savings, because although the facts are different, you still had the same question of whether the court should use cross-class cram-down to impose a plan on a dissenting class whose interests were different to that of the assenting class. And we agree with the judge in what he says at 103 and then at 106 as to the questions that arise on that sort of scenario.
You showed us that Mr. Justice Adam Johnson found particularly helpful a couple of academic articles. We've not been given those. Do you place any reliance on them? Are they of any help?
I mean, we've limited the material. I mean, we rely on them. I mean, I'm very happy to provide copies to your lordships. I suspect my Lord Justice Snowden is familiar with them because they're referred to in Virgin Active. I mean, what we rely on primarily is the fact that the court is looking at those articles, and the type of analysis that is set out in those articles indicates that the question of fair allocation of the restructuring surplus, fair allocation of the benefits of the plan, is undoubtedly one of the questions that the court has to consider.
I mean, I think it's fair to say from recollection and re-scanning, but only briefly, I don't immediately detect any material difference between what Mr. Justice Adam Johnson said and the debate in those articles.
No.
I mean, he referred to them, and I think a lot of what he said is he's picked up one or two things from those articles. But
indeed, much as your lordship did, of course, in Virgin Active as well.
yeah, I mean, they're helpful articles at least to formulate and frame the debate. Anyway,
They do.
because everybody's trying. I think, as Professor Patterson said in her article, I mean, everybody's on the hunt for a framework
Yes.
for the exercise of discretion, given that Parliament gave the discretion but not the framework.
Exactly right. But exactly, and the question, the only point I need to establish at present, and this is simply my submission, is that when you're in circumstances of having to exercise cross-class cram-down, where you've got a dissenting class whose interests, by definition, are different, one of the relevant questions you have to consider is not what the alternatives to the plan are, or the other side of the same coin, what alternative way might the benefits and risks be allocated. And fundamentally, where the judge seems to have gone wrong is not opening his mind to that question, and therefore not really considering the fact that in this case everything could have been done,
But I
whilst
think
respecting the pari passu distribution.
But I think one of the points that it's not a free range. The judge. It's not a free range discretion in the sense that you don't look at how things might otherwise have been done just because you might like the look of something else. I think that's the point Mr. Justice David Richards is very much making. For example, in Telewest, it's really not for the judge to say, well, I might have done it a little differently, just in the abstract.
Well, I agree. It's not an abstract, but what
You look at it. Isn't it right that you look at it in the context of how could some other defect that's been identified be addressed? I mean, as I understand your argument, although you put this point first in your first ground,
Yeah.
the core of your argument is, look, this is put forward as an alternative to a liquidation. In a liquidation, we'd be dealt with pari passu. There's no justification for departing from that. And there was an alternative. So in a sense, you get to this point about, look, there is an alternative. In a sense, at the end of that,
you do.
at the end of that sort of analysis, I think I'd be considerably more resistant to your proposition if it was put first.
Yes.
Namely that a judge, poor old judge, as if he didn't have enough to do in these cases, shouldn't have to sit there and start thinking about other plans and schemes that might have been put forward in the abstract.
I agree. I respectfully entirely agree with what your lordship said. And as I said at the outset, the critical piece of context in the present case is the alternative of pari passu distribution. And the question, therefore, is, well, why, if you're doing a wind-down plan, why don't you simply do it pari passu? The plan company hasn't done that, and they've come forward with a different plan. They don't have any good reason for saying they're not doing it pari passu. And our point is simply, well, it's no answer to that, our complaint, for the court to say, oh, well, you can't look at alternatives, you just look at the plan that's before you. And this is what ground one is. I mean, you can't shut your mind and say, well, no, the scheme jurisprudence says you just look at the plan you've got.
Because the trouble is, otherwise, you would be encouraging an approach which a lot of the cases do seem to suggest is prevalent, which is a plan or scheme company puts something in front of the judge at the last minute and just says, here you are, judge, there's no alternative.
Yes, exactly.
It's this or Armageddon.
And in some ways...
So what are you going to do about it, judge?
Exactly.
And that's not appropriate.
And in some ways, I mean, going back to the point which you made a moment ago, I mean, in some ways this case is perhaps an easier one than some other cases because the relevant alternative and the pari passu distribution provides the framework in our submission. It gives you a framework because it tells you what the alternative will be, how creditors will be treated in that alternative. And therefore what the court can do is judge the plan by reference to that yardstick and ask itself, well, if you're departing from that framework, is there a good reason for doing that? If there is, well, fine. If there isn't, well, that rather suggests the plan's unfair.
Yes, I do wonder whether this is a separate point, this ground one, because as you, I think, have accepted from my lord, your starting point is the relevant alternative is insolvency. Under insolvency, we're all treated equally. Is there this plan departs from that? Is there a good reason for departing from it? And then right at the end you say, not only has no good reason been put forward to depart from it, but you could very easily have done exactly the same thing, except for harmonise the maturity date so that everybody is treated equally. And it is really that last point. And if you don't start by looking at a plan and saying, well, are there other plans? Is this the best one? You start with what you say is the defect in this plan and say, is there a reason why we have to put up with that?
Yes, I mean we respectfully agree with that, and I think the reason we're dealing with it this way is as we understand the judge's judgment. It's not entirely easy to follow the reasoning in places, but as we understand it, what his answer to that point, which we would submit is the correct point, was essentially to say, well, no, look at the scheme jurisprudence. You don't ask yourself whether it's the best plan or the fairest plan. Therefore,
but I mean, the same is, I don't myself see any vast divergence between what the court is trying to do with a Part 26 scheme and a Part 26A plan. What it's trying to do is check the statutory preconditions are satisfied and then decide if it should be approved or not, and whether it should be approved or not depends on whether it's fair, which is the word used by Mr. Justice David Richards in Telewest. It's simply that in a case where all the classes have reached the statutory majority, it's much easier to come to a conclusion it's fair, because honest and intelligent, commercially minded people could properly come to that decision, and the court has to have some real reason for saying, but I don't think it's fair. Whereas in a Part 26A one, you start from the position that somebody who has a different interest, because otherwise they shouldn't be in a different class, has not reached the requisite maturity, and therefore it might be easier to conclude that it's unfair. But it's still the same question, isn't it?
well, it is. Yeah, I mean, I think it's the same question. It's just the nature of the nature of the extent to which the court engages with that question. And in the Part 26 context, in my submission, the court takes a relatively light touch view. It's got the vote in all the classes. If it looks rational, well, fine, creditors are best judge of their own interests. Not really the same in Part 26A, where you've got one or more dissenting classes, and the court does have to engage with what might actually be the same question. It's just a question of the extent to which the court defers to the views of the creditors.
Yeah, I mean, without wishing to go over old territory and delay you too much, but it is possible that you could adopt the same approach in a Part 26A plan in relation to a dissenting class if the dissenting class has dissented for no apparent reason connected to any differential treatment. And that's maybe the explanation for Sir Alistair Norris's decision, in the sense that the question about whether to allow shareholders to retain the equity in Amicus Finance was one that affected all the classes of creditors who were asked to take some form of compromise.
Yes.
And 4 of the classes said, yeah, all right. And the other one said no.
Yeah.
And he may just have been saying, well, in essence, on this particular issue, there is no difference between you. On this particular objection, you could have been put into the same class.
Yes.
And so I will just apply the scheme approach of saying, I'll go with the rational 4 classes rather than the one class which, on this point, doesn't have any different perspective.
I mean, I entirely see that, and obviously my response to that is, well, yes, but that isn't our case. So
No.
yeah. But I mean, I see that as a rationale of amicus. So the other point we would wish to make, just in relation to ground 1 and the question of the law, was the judge's dismissal of the help that might be gained from the CVA cases. Now, in our submission, there is useful guidance to be obtained as to the exercise of the cross-class cram-down power from the CVA cases. Of course, we accept that CVAs are a different type of procedure provided for by Part 1 of the Insolvency Act. And a key feature, as your lordships will know, of CVAs is that all the creditors vote in a single class, irrespective of any difference in existing rights or difference in rights under the CVA. Effectively, everyone just votes in a single group. And if a particular creditor then thinks it's been treated unfairly, it has the statutory right to apply to the court to set aside the CVA on grounds of unfair prejudice. So the, if you like, mechanic of protecting the interests of creditors isn't through the way in which the classes are constructed, it's through the statutory right given to apply to the court. Now, as we say in the skeleton argument, as your lordships will, I think, know, that the court has developed 2 tests as part of the test for unfair prejudice, which are called the vertical comparator and the horizontal comparator. The vertical comparator essentially says that creditors really have to be no worse off than the position in the relevant alternative.
The same as condition A.
Exactly. It's functionally equivalent to condition A.
Well, it was functionally equivalent to what Justice David Richards said in Reed T&N.
Exactly.
I mean, no judge would ever sanction, absent extremely good reason, a scheme
Exactly.
which gave people a worse outcome than the alternative.
Exactly.
Because no rational creditor would, on the whole, vote in favour of a scheme which
make them worse off
than if it wasn't there.
Exactly. So the vertical comparator, and you refer to sometimes as baseline fairness. It's essentially the threshold test. If you can't get over that, you don't get off first base in reality. The second comparator is the horizontal comparator, which looks at how creditors are treated under the CVA relative to each other. So it's focusing on the question of relative treatment. And in our submission, that does raise the same question, which also arises with the exercise of cross-class cram-down, as to whether the way in which benefits are allocated between different groups or creditors is fair. Now, if I can just show your lordships 2 of the cases which have made this link in our submission correctly between CVAs and the cross-class cram-down power. The first is a decision called Deep Ocean, which your lordships will have in your lordship's second authorities bundle behind divider 23. This is a judgment of Mr. Justice Trower, and in fact it was the first case where cross-class cram-down was invoked.
I'm sorry, which tab?
It's tab 23, my lord. Hopefully your lordship's second authorities bundle.
Thank you.
So it was obviously a Part 26A restructuring plan case. It was a case where cross-class cram-down was relied on by the judge to sanction the plan. And for present purposes, I just wanted to draw your lordship's attention to what the judge said in paragraph 62 to 63. This is page 716. So he's dealing here with section 901G, and he says, having identified some other points, the next discretionary factor that may apply in section 901G cases relates to the relative treatment of creditors under the proposals, and has much in common with what has come to be called the horizontal comparison that the court will often carry out when considering an unfair challenge to a company voluntary arrangement. It's the second of the two heuristics referred to by Mr. Justice Norris in Debenhams. It compares the treatment of creditors under the CVA in to say, as Mr. Justice Norris says, well, there's no prohibition on differential treatment. Any differential treatment must be justified. In my view, because a class right of veto is removed by operation of section 901G, justice may require the court to look at questions of horizontal comparability in the context of a cross-class cram-down to see whether a restructuring plan provides for differences in treatment of creditors in to say, and if so, whether those differences are justified. In particular, the court will be concerned to ascertain whether there's been a fair distribution of the benefits of the restructuring, what some commentators have called the restructuring surplus, between those classes who have agreed the restructuring plan and those who have not. So again, the judge in our submission entirely correctly identifying that one of the questions that the court has to look at when deciding whether or not to exercise cross-class cram-down is the relative treatment of creditors, whether the allocation of benefits is fair, and that has much in common with with the exercise which the court undertakes when considering whether a CVA ought to be set aside on grounds of unfair prejudice. So in our submission, that is helpful, and we respectfully agree with those paragraphs. The other case, which it's worth looking at, is actually a CVA case, which makes the comparison in the other direction, and that's the judgment of Mr. Justice Zaccaroli in New Look, which your lordships will have behind divided 27, which I think is also in Authorities Bundle 2. So this was actually a case of a CVA in relation to the New Look retail store, where there was an application to set aside the CVA on grounds of unfair prejudice, which was refused by the judge. And one of the complaints that was made in New Look was about the relative treatment of creditors as between each other. So in other words, the horizontal comparator test. The particular points I want to draw to your lordship's attention is firstly paragraph 147 on page 826. Paragraph 147 in our submission is noteworthy because the judge here comments on the test, the familiar test in relation to schemes of arrangement, and notes the tension between that test and what the court has to do in relation to challenge of CVA on grounds of unfair prejudice, and also in relation to where the court is considering the exercise of the cross-class cram-down power. Because what he says in 147, one feature of the scheme fairness test is the court's concerned only with the terms of the scheme actually proposed. It does not inquire whether a different scheme might have been better for particular groups of creditors. And then he cites, in this instance, the Co-op Bank case for that. In both CISU and Powerhouse, it was said that the same approach applies in the context of a CVA. There's a tension, however, with Mr. Justice Ferris's comment in Rea Debtor that was also cited with approval in Powerhouse, that in considering whether an arrangement creates unfair prejudice for a creditor, it's necessary to look beyond a comparison with that creditor's position in bankruptcy because, among other things, the alternative to the arrangement include the ability to press for a more satisfactory arrangement. There's similarly a tension with the approach suggested by Mr. Justice Trower in the context of the exercise of the cross-class cram-down power under Part 26A, with which I respectfully agree that it's necessary to consider whether the plan involves a fair allocation of the restructuring surplus between different subgroups of creditors. And in my submission, that's referring to the paragraphs in Deep Ocean, which we've just been looking at. And he recognises, in effect, that both in the CVA horizontal comparator context and cross-class cram-down context, that scheme principle can't be applied in quite the same way. And then 196 he in this part of his judgment essentially deals with his conclusions on the unfair prejudice question. And what's relevant for our purposes is 196, where he says, for the reasons I've expressed at paragraph 147 above, in considering whether the allocation of assets is fair, the court is necessarily required to consider whether a different allocation would have been possible. So the principle in scheme cases against considering whether an alternative arrangement would have been fair and needs to be modified. So,
without wishing to sort of, as it were, poke you in the ribs unnecessarily, I mean, what he's dealing there with is rejection of your argument in paragraph 189, isn't he?
Quite. Rightly rejecting it, I might add. Because I submitted to him, as you see in 189, that that essentially you got there, or I got there in New Look by simply saying the vertical comparator was met and that the scheme rationality test was met. And he rightly rejected that, essentially for the reasons he gives in 147 and 196, because he said, well, that can't really be an answer in assessing whether a CVA is fair and whether the allocation is fair. Necessarily, you need to look at what the alternatives are. I mean, my submission, he was right to reject that submission that was made to him, and correct to put it in the way in which he did. Now, the judge in this case thought to distinguish New Look at paragraph 77 of the judgment. And this is page 786 of the bundle. And it's essentially the third and fourth sentence of paragraph 77. He begins by referring to my learned friend's submission and my submission, and then refers to amicus, which we've looked at. And then in the fourth sentence, he deals with New Look. And he deals with it by referring to what Mr. Justice Zaccarelli said in paragraph 199 of New Look. Now, in our submission, that paragraph, 199, is dealing with a rather different point. There, Mr. Justice Zaccarelli was saying that the fact that the same results might be achieved by a Part 26A plan doesn't itself necessarily make a CVA fair. The procedures are different, and the way the protections for creditors are put in place differ. But that, with respect to the judge, doesn't affect the point we're actually concerned with, which is that the question of unfair prejudice in relation to a CVA and the exercise of cross-class cram-down both raise the same question of whether the allocation of benefits between creditors is fair. And in both cases, as part of answering that question, it's necessary to look at whether some alternative allocation of benefits might be fairer. So we do submit that you do get assistance with what's said in the CVA cases, essentially grappling with the same question in a different context. And you can see in those cases the judges accept in our submission correctly that you can't simply apply the scheme principles directly, and in assessing fairness you do need to look at the question of allocation of benefits and whether there may be an alternative. Now, just 2 points to pick up from my learned friend's skeleton argument on this point. If you go to paragraph 12.4 of his skeleton, divided 10 of core bundle 2975, there's a lot of citation of authority in paragraph 12.4, apparently cited in support of proposition, I think that the scheme proposed need not be the only fair scheme, or even in the court's view, the best scheme. In our submission, the authority cited there doesn't really support the proposition when you look at it. I'll just deal with the cases in turn, if I may. The first is Virgin Active, my Lord Justice Snowden, which is in Authorities Bundle 2, Divided 28. We can just go straight to the relevant paragraph which is cited, which is 221, page 908 of the bundle. Now 221 my Lord Justice Snowden refers to the Telewest test set out by David Richards, and the point which my Lord is making in 221 is essentially directed at the conclusion that there isn't a test for cross-class cramdown of whether the plan must be just and equitable or not. And essentially, that's for the reasons you see in 219, that the words just and equitable, as we were submitting earlier, don't by themselves really assist. As my Lord says, I say that because if posed as a question, would the court sanction a plan it did not consider to be just and equitable? As Mr. Trepp pointed out, the answer is obvious, it would not. But without a frame of reference to assess what is or is not just and equitable, such a test would be meaningless, would not carry matters any further forward. And the point that's made in 221 is essentially buttressing that point. The key point is actually the paragraph that my little friends don't cite, which is the next paragraph, which is 222, where my Lord went on to say this. Further, and for the reasons set out above, whilst a rationality test can be applied when considering whether to sanction a scheme under Part 26, which has been approved by a majority in each relevant class, the same test cannot necessarily be applied in the same way when the court is considering whether to exercise the power under Section 901G to sanction a Part 26A plan against the views expressed by a dissenting class. So, in our submission, if anything, Virgin Active supports the view that you can't simply transplant over the scheme tests where one's dealing with cross-class cram-down. And I've also already showed your lordships 255 and 256 Virgin Active, where my Lord plainly contemplates that where you're dealing with a situation where there's in-the-money creditors in the assenting class and in-the-money creditors in the dissenting class, you do have to look at the question of fair allocation of benefits. Deep Ocean is Authorities Bundle 1. Sorry, Authorities Bundle 2 for your lordships. Divider 23. The relevant paragraphs which are referred to are 20 to 21, which are at 709. So paragraph, this is a good example actually, why these citations need to be treated with some care, because if you go to paragraph 20 on page 708, Mr. Justice Snowden essentially sets out the very familiar extracts from Telewest, National Bank and Buckley. And then paragraph 52 summarises how my Lord Justice Snowden had paraphrased those. But what he says in 21 is this: for reasons I will develop shortly, it seems to me that a slightly different approach is required on an application to sanction a Part 26A restructuring plan where the applicant seeks to rely on provisions of Section 901G. However, several aspects of the approach remain applicable, the first of which is whether the terms of the statute have been complied with. Well, we agree.
Just to disentangle that for a second,
Yeah.
to be very clear what he's doing. He's referring first to Virgin Atlantic, which is not obviously the same as Virgin Active.
Correct, yes.
Virgin Atlantic was the first
Restructuring plan.
plan, but no cross-class cram-down was required.
Correct.
Because all the classes had in fact voted in favour.
Correct.
So I just said, well, this is just like an old-time scheme. So I have just applied the rationality
Correct.
test as you would if it had been a scheme. So it was not a cross-class cram-down case.
Exactly.
And you know, I did so by reference to the established principles.
Exactly.
Likewise, Noble Group was a scheme case, not a plan case.
Exactly.
And all Mr. Justice Trower is doing is saying you may have to have a slightly different approach where you're asked to, or you may a slightly different approach is required if you're cramming down.
Exactly. And indeed, if you then go on, you get perhaps more illuminating is what he says in paragraphs 44 to 46, 714 of the bundle, where he says the words of the statute give little guidance on the facts that are relevant when the court is exercising its discretion to sanction a restructuring plan. Well, that's true. But I think that even where Section 901G is in play, the approach the court adopts when sanctioning a scheme under Part 26 or a restructuring plan under Part 26A, where the provisions of Section 901G are not relied on, as to which see Virgin Atlantic, the point my Lord's just made, is the right starting point. I've outlined them earlier in his judgment, so that's obviously what he's referring back to. But then this, in a Section 901G case, there are, however, some necessary differences from the National Bank Telewest test, and in particular the important phrase, but at the same time the court will be slow to differ from the meaning. The reason for this is that where a dissenting class has not agreed the compromise arrangement by the statutory majority, the cross-class cram-down is being sought. The legislative intent is it may well be appropriate for the court to exercise its power to differ from the dissenting class meeting if conditions A and B are satisfied. By its very nature, the power to be exercised under Section 901G contemplates that the court can override the wishes of a class meeting. So that whole idea of, well, you just defer to the views of the meetings, I mean, as he explains there rightly, you just can't transplant that across. So we suggest really, and then I've already showed you then also 62 and 63 where he then goes on to identify one of the relevant discretionary factors as being the horizontal comparator in the allocation of benefits. So we submit Deep Ocean doesn't provide any support at all for the idea that none of this is relevant. To the contrary, amicus I've already dealt with, and we've looked at paragraph 45 of amicus. Housed, my learned friends refer to paragraphs 24 to 26 of Housed, which is in the third authorities bundle at tab 35. So I think pick it up first at 24 to 26, which are the paragraphs on my learned friend's side, page 1059. And he essentially takes the same approach as Mr. Justice Trower did. That's a perfectly understandable approach, which is your starting point is, well, let's look at the scheme principles. Those can apply as a starting point. But as he says in 24, you need to make modifications to account for the differences between the regimes, particularly where cross-class cram-down power is engaged. And then 26, as he says, echoing what Mr. Justice Trout said, a principal point of difference between the two regimes is the extent to which the court might be slow to differ from the views of creditors. as Trower J pointed out in deep ocean, this cannot have the same place in the court's approach to sanctioning restructuring plan when the court's required to override the groups of one, well, required to override the wishes of one or more groups of creditors. And then again, then you go on at 37 to 38 because and this is interesting. This section really begins at paragraph 33. Now, just to give you the context, in the House, Mr. Justice Zaccarelli sanctioned a restructuring plan, which effectively departed from the order of priority.
You're going to come back to paragraphs 29 and 30 at some point, presumably on when we actually look at.
Yes, I mean that's obviously very helpful for us. 29. I mean,
well, it's just I think you're still on ground one, aren't you?
I am. Yes.
Okay.
Yes. Yes. I mean, yes. I mean, this is your lordship's referring to the fair wind point, to give it that short terminology. But
well, actually, I wasn't. But I mean, there is perhaps a difference of has been a difference of view expressed as to whether. As Mr. Justice Trower said, if you satisfy A and B, conditions A and B, you have a fair wind to sanction.
Yes.
I think I probably was a little more resistant to that in Virgin Active. I don't think I thought it was so much a fair wind. It's just you then move to stage 3 and you have a discretion to satisfy.
Exactly.
But I wasn't particularly. I don't think anything's going to turn probably on the question of fair wind or otherwise. It was more 29 and 30 are, I think, relevant, but really probably not on ground one. Although 30 does point out you do have to essentially look at the horizontal comparator.
Yes, exactly. So, I mean, I think it probably is relevant to look at 29 and 30 at this point because it then leads into what he says at 33 and provides the, if you like, the framework for that. So 29, an important factor, particularly considering sanction where the cross-class criminal empire is engaged, is whether the plan provides a fair distribution of the benefits. And again, he refers to the Dr. Mokal articles, and then he refers to deep ocean, which we've already looked at. So again, yet another restructuring plan case that suggests you do have to look at this question. Paragraph 30, the first sentence, is in our submission important, and that's echoes one of our submissions in this case, in that a relevant reference point undoubtedly is the treatment of creditors in the relevant alternative. And obviously we made the point in the present case by reference to the pari passu treatment. We respectfully agree with Mr. Justice Zaccarelli that a departure from that priority is not in itself fatal. Our submission is that it wouldn't necessarily be fatal, but you would need a good reason or proper justification for it. And he points out that there isn't an absolute rule to that effect in England compared to the position in the US. We don't say that there is an absolute rule in England. But then he goes on to, in paragraph 31 onwards, to essentially carry out the exercise of assessing whether there has been a fair distribution of benefits to the restructuring. And you'll logically see the way he approaches that in paragraph 32 is essentially to look at the normal factors that would be relevant to a Part 26 scheme. He effectively goes through those in paragraph 32. And then in 33, he goes on to look at the question of fair distribution of benefits. And he notes that it involves a clear departure from the order of priority between creditors that would exist in the relevant alternative. And essentially for all the reasons one sees set out in 34 to 46, he nonetheless decides he will exercise his discretion to sanction the plan. And those include, for example, in 40, the fact that the value in that case came from a capital injection from the shareholders. Paragraph 42, secondly, HMRC had not, in fact, turned up to oppose the plan. and they were a sophisticated creditor. And thirdly, HMRC had not stood to receive a better outcome and not sought, for example, to negotiate an alternative deal. Now, one of the points, so for all those reasons, having identified the question, considered it, he decides in that case, in effect, there is good reason to depart from that, and it led there to the ability of that company to continue as a going concern. One of the points that we will come back to is what he also says in paragraphs 37 and 38 before he gets to that analysis, because one of the points which he regards as a weak reason for cramming down HMRC is that this was the deal that was put forward was said to be the one that was supported by the creditors. And he says that's a weak reason because you can always do an alternative where you could have relied on HMRC as the assenting class to cram down the other creditors. And it's those paragraphs that Mr. Justice Adam Johnson relied on in Great Annual Savings as showing that you do actually have to consider alternatives. And the alternative he's considering there is a differently formulated plan where HMRC would have been the assenting class. And you would have used HMRC's vote to cram down the dissentients. But all of that shows, in our submission beyond doubt, that when you're in the cross-class cram-down territory, you do have to engage on this wider question of looking at the fair distribution of benefits and looking at least looking at the question of alternatives. So we submit House to the contrary is an authority strongly against my learned friend. The reliance on list track midco, I'm afraid, is just a bad point. This is one of the other cases relied on, paragraph 53 of list track midco. I'm afraid I have to deal with these given they've been cited, but this one's a bad point. It's divider 37 of the authorities, volume 3. It was another restructuring plan case. What's very important when you read the judgment is that there were 7 restructuring plans. In the case of 4 plans, there was no need to rely on cross-class cram-down. In the case of 3 plans, we did need to rely on cross-class cram-down. So effectively, the plans fell into 2 groups, the ones where we didn't need cross-class cram-down and the 3 where we did. The paragraph my friend cite, in fact, relates to the judge's treatment of the plans that didn't need cross-class cram-down. If you go to, they cite paragraph 53, which is at 1116. Where the judge referred this time to what my Lord Justice Snowden said in the KCA Dutard case, which was a Part 26 scheme case, of course. But if you go back to paragraph 45, 1115, you can see here he's dealing with the plans that didn't need cross-class cram-down. And essentially he took the same approach as your Lordship did in Virgin Atlantic, which is to say where you've got a Part 26A plan that doesn't need cross-class cram-down, well, it's not materially different from a scheme, we agree. But what matters is actually not the paragraph my learned friends cite, but what the judge deals with in paragraph 58 onwards. At 1118, because having dealt with the 4 plans where cross-class cram-down wasn't needed, he then says, I then come on to LCC, AC, UKL and VML, the 3 plan companies in respect of which sanction is dependent on cross-class cram-down. And then you'll note paragraph 68, he actually makes the contrary point to the point my learned friends are citing this case for, expressly makes the point that in the context of cross-class cram-down, a further factor is whether the proposed compromise involves a fair distribution of the benefits of the restructuring C, Deep Ocean and Virgin Active. I'm persuaded that's the case here. The relevant paragraph is actually paragraph 68. It's to the contrary of the submission made. My own friends refer to gas at great annual savings at paragraph 95. This is divider 39. And 1188, they refer to paragraph 95. All the judge is doing in paragraph 95 is setting out the familiar test, this time derived from my Lord Justice Snowden in Noble Group, the four-stage test. What they ignore is what the judge says in paragraph 98 onwards. Now, I showed your lordships this before, but the relevant part is actually paragraph 99 to 106, where he explains that in the context of cross-class cram-down, the fairness test has to be approached rather different, in a rather different way. So again, authority is actually contrary to what's said in the skeleton. And then the final one they rely on is Prezzo, which is in Authorities Bundle 3 at divider 40. And this was another restructuring plan case where, on this occasion, cross-class cram-down was used to cram down HMRC. And my learned friends refer to paragraph 55, which is at 1211. And again, this is just the KCA-Dutag test. But it's a very poor citation because they simply ignore the relevant bit, which is actually paragraph 57 onwards, where the judge goes on to explain the additional and different factors that apply where cross-class cram-down is being invoked. And if you go to 68, 1213, he identifies in a quite a useful way some of the factors that are relevant to the exercise of the discretion to effect cross-class cram-down. And those include under Roman numeral 3, whether the plan provides for fair distribution of the benefits of the restructuring. When considering, and then Roman numeral 4, when considering if a plan fairly allocates value between the different creditor classes, it's relevant to consider whether the priorities between them in the relevant alternative is reflected in the distributions under the plan, albeit a departure from that priority is not in itself fatal to sanction. We agree. But all of those are additional factors that come into play where you're dealing with cross-class cram-down. Now, the other point, so none of those authorities really, when you look at them, really support Malifred. To the contrary, we would rely on those authorities because they support our submission as to the extent of the inquiry. The other point, and I've already made this, is that in relation to the first sentence of paragraph 12.5, it's a mischaracterisation of our submission to say that we say the test is that the plan has to be the best plan. We don't put that as the test. As I said, what our point is that in the particular circumstances, one needs to look at the question of alternatives. And that's particularly where here one's deviating from the alternative of a pari passu distribution. So, well, that's ground one. Ground two I can deal with much more briefly because it covers some of the same ground. This concerns the way in which the judge applied the honest and intelligent person rationality test. And we say, again, that can't be applied so as to answer the question of whether cross-class cram-down should be exercised. To be clear, there isn't actually any harm in the court applying that test. It's just that it can't itself answer the question.
Invariably, as I understand the way that the authorities have gone, and in a sense Virgin Atlantic Airways starts this, but others have followed, including, I think, some of the authorities we've just been looking at. where you are asked to do a cross-class cram down, your starting point is just to check that the assenting classes have been acting rationally in the way that you would on a scheme.
Exactly.
So if in fact Virgin Atlantic, you're not cross-class cramming down, you just check in the ordinary way with the scheme. But as soon as you are asked to cross-class cram down, doesn't mean you ignore the rationality test from schemes, at least checking that the assenting classes are assenting for a good reason, a rational reason, because they are the basis on which you're being asked to cram the whole thing onto the dissenting class.
Exactly.
So if they were acting in an irrational way, a fortiori you shouldn't be cramming down on the dissenting class.
Quite agree, and you can see from the judgments the way in which a number of the judges have approached it is by effectively taking the starting point as applying the scheme test, and then if it's cross-class cram down, you then go on to apply the additional factors that arise as being relevant to that specific exercise. But
whilst not forgetting that you, in a sense, that you have important point. You mustn't. I think, as one of the authorities said, you mustn't forget the fact that you do have a big chunk of creditors who are acting rationally, at least in their own interests.
Yes, exactly. You don't forget that, but the point is, it doesn't provide by itself the answer, and in the context of cross-class cram down, it doesn't really do much of the work, because ultimately, when you get to the stage of cross-class cram down, you have to ask yourself whether the distribution of benefits is fair or not. Now, the way in which the judge deals with this, you see in the judgment, and it begins at paragraph 295. This is page 896. Although it's a long judgment, it's actually really only when you get to paragraph 295 that you really start to get the analysis. And the way the judge deals with it is to deal separately with the different ways in which the plan departed from pari passu. He deals with the different maturity dates, firstly, and that is essentially, you get his essential reasoning on that in paragraph 302. Now, interestingly, he doesn't mention the honest and intelligent person test there at all in those factors in 302, dealing with the maturity dates. He then comes in 303 to deal with the priority security point, so the fact that the 2024 sons get security which ranks in priority to the security given to the other sons. And in that context, this test does appear in paragraph 306.2. He references it by picking up EDF and man at paragraph 54, and then he also references this test, seemingly as one of his main reasons, in paragraph 310.2, why he says it was why there were good reasons to exclude the convertible notes from the plan. Now, if you go back to 306, so one of the difficulties one has on the judge's approach is that there isn't any prior discussion of the honest and intelligent person test, and it just appears for the first time in paragraphs 306 and 310. So there isn't an explanation or discussion of what role the judge thinks it should play in relation to the analysis, or what weight you should attach to it. But the impression one gets from 306 and 310 is the judge did regard the satisfaction of this test as a key factor to which he attached significant weight when it comes to the question of cross-class cram down. Now, in our submission, he was wrong to do that. I've already identified, I think, the key provisions, key parts of the first instance authorities which explain that rationality test can't be simply transplanted over. I'll just give your lordships, the references, because we don't need to turn these up again. It's Deep Ocean at paragraphs 45 to 46, Virgin Active at paragraph 214 and paragraph 222, Hurricane Energy, which I don't think we have looked at, but it's I'll just give you your lordships a citation at paragraph 40, and Great Annual Savings at paragraphs 100 to 102, which we've already looked at. And in our submission, the statements in those authorities are all correct. The judge referred in paragraph 306.2 to EDF and Man Holdings at paragraph 54. And you can see that in the authorities bundle, third authorities bundle, divider 32.
You're going to come back and deal with 306.2 on the facts at some point, I assume.
Yes, indeed I am.
You're
Yes.
simply dealing with the question at the moment about whether the honest, intelligent person might approve the plan
Correct.
test should have been used at this stage of the analysis.
Correct, exactly. And just to finish that, the judge referred to paragraph 54 of ED and F Man, that's divider 32, authorities bundle 3, begins at 1007. This was, again, a restructuring plan case. And if you go to 1015, the judge deals with the question of the exercise of discretion in that case. And you can see from paragraph 49 onwards, he begins by identifying that the conventional approach to Part 26 scheme is satisfied. And then he goes on to identify the other, and then he goes on to identify the reasons why that is the case. And one of the reasons why that is the case is what he says in paragraph 54. So all of that is going to the judge's starting point of asking himself whether the conventional approach to a Part 26 scheme is satisfied. But what you see...
Well, what he's doing here is doing exactly what I said a few moments ago, surely. As you said at paragraph 49, he's dealing with the plan meetings which have agreed the plan
Yes.
by the statutory majorities. And he says, I say that for the following reasons. And then he says the provisions of the statute complied with, no evidence to say that the assenting classes were not fairly represented, no member of the assenting class acted other than bona fide.
Yes.
He hasn't suddenly switched. He's dealing with the assenting classes.
Exactly,
all the way through this passage.
Exactly. And in relation to the assenting classes, makes perfect sense to apply the conventional scheme approach, and you go through, if you like, the Telewest checklist or the Noble checklist and check that that's being done. But that isn't the end of the exercise when you're dealing with cross-class cram down, because you then go on, and he does indeed go on, to deal with the other matters, which he identifies in paragraph 55 onwards. And one of them, 55, he looks at the question of the overall vote. 56, he looks at the fact that none of the opposing creditors actually appeared to oppose the plan, which was also a factor that Mr. Justice Zaccarelli relied on in-house. But then thirdly, paragraph 58, what is very important is what the judge went on to consider there, because he says, thirdly, there's no reason to consider that the benefits of the restructuring plan, what is sometimes called the restructuring surplus, is being shared in an inequitable manner which does not reflect plan creditors' existing rights. The plan itself respects the current ranking of creditor claims. So a critical question for the judge in E&F Man, not referred to by Mr. Justice Leech, is the fact that Mr. Justice Trower had gone on to look at the question of allocation of benefits, the restructuring surplus. He'd compared that against the framework of creditors' existing rights. In that case, he noted that that current ranking was being respected, and therefore that was obviously didn't constitute a reason not to to exercise cross-class cram down. So, I mean, it's a little difficult to sort of unpick the judge's judgment because of the way he approached it, but the way, if he was suggesting that the honest and intelligent man test somehow supplies the answer to cross-class cram down, in our submission, that's not right. And you need to go on to consider these important other important considerations as well. And we don't say the honest and intelligent person test has no role to play. It's just it's not the final word. It's merely a staging post in the analysis. And the other point we'd make in relation to this, and I think your lordships have already got this point, is that the honest and intelligent person test obviously doesn't work as supplying the answer when it comes to the question of whether or not to exercise cross-class cram down, because you've got, by definition, different views between different classes with different interests. And it may be perfectly rational for the assenting class to like the plan by reference to their interests, and it may be perfectly rational for the dissenting class not to like the plan by reference to their interests. Those may be perfectly rational points of view by reference to their own different interests. So applying the honest and intelligent person test doesn't really help you answer the question. They may be both perfectly intelligent, rational points of view to come to.
What about the point that, in fact, here, the so-called dissenting class, the majority of them did vote in favour of the plan? It's not like a case where the dissenting class, by an overwhelming majority, rejects the plan.
Yeah.
So there were some presumably honest and presumably intelligent people in the class of 2029 note holders who thought, well, I can see it's not quite as good for me as it might be, but it's good enough.
Yes. Now, in that majority, and we'll come to the figures in due course,
there are some people who have interests in other holdings.
Most of them have
Yes.
cross holdings.
So their motivation may be mixed. And
Yeah.
You might be able to, but some of them don't.
Some of them don't, and then you're down to what we call the pure 2029s, who are actually a very small group in terms of value. I think it's about 3% of the total 2029 sons. Some of them have very small holdings indeed. But we talk about the 35. I think perhaps 9 of them hold no more than 100,000. And the question is, well, they were obviously, presumably, to the extent they engaged with the plan at all, reliant on what was being told to them in the explanatory statement. But even more fundamentally, I mean, even if one assumes that they were perfectly rational and they did look at this, that vote in our submission can't itself provide a good reason for the prejudicial and differing treatment given to the 2029 sons if objectively there is no good reason. I mean, you can't, put it another way, you can't rely on that vote, less than the statutory majority, as supplying a good reason for the differential treatment where there is otherwise no good reason. Because otherwise what you're in effect doing is saying, well, it doesn't matter you haven't hit 75, it's actually enough that you've hit 62. That's enough. I'm going to treat that as being the reason to sanction the plan. And that's obviously not what the legislation has in mind. I mean, what if it was, I mean, the logic of that point is that it's enough to get to 51%, and then, you know, suppose you've got 51%, then the court will sanction the plan no matter how egregious the treatment. But if that's correct, then you're just substituting 51% for 75%.
Speaking for myself, I would at some point like to be walked through the tables
Yes.
of anonymised bondholders by number. I don't find it remotely easy to draw some of the numerical conclusions that seem to be drawn, not least because I don't think we've been provided with the correspondence which was exchanged between solicitors about the composition of the SteerCo for a start,
Yes.
and the like. I mean, if
Yes.
we're going to get into this sort of area in any detail, and I think they need to look at it,
Yes.
depending on what Mr. Bayfield
Yeah.
says, because Mr. Bayfield, I think, does rely upon the fact that there was a majority,
Yes.
both in number and value, of pure 2029 bondholders
Yes.
who voted in favour, as well as the majority of bondholders, 2029 bondholders in the wider sense,
Yes.
of people who had cross interests.
Yes.
But if we're going to get into that sort of analysis, speaking for myself, I think I'd quite like to have a little bit more information than I think we've currently been given.
Yes. Well, we can try and supply that. I mean, it's.
Well, I mean, for example, I don't know who the SteerCo is.
Well, I'm not sure we know who the members of the SteerCo are. We may know.
Well,
we may know.
I don't mean their names. I mean who, for example, are the SteerCo when identified by number. And
Oh, I see.
actually-
So which of the SteerCo on the anonymised list?
Yeah, because there clearly has been a debate about these
Yes.
points between the parties.
Yes.
And actually the same for your clients.
Yes.
I don't actually.
Well, yes.
I don't think I actually know who your clients are by anonymised numbers either.
So it's essentially when your lordship's talking about that schedule of the votes, which is anonymised. It's sort of indicating on that schedule
Well, who's who?
who's who. Yes. Well, we can.
I know everybody gets remarkably hot under the
Yeah.
collar about the idea you might actually have to tell us who you represent.
Yes.
People do in these sort of cases for reasons that
Well, I mean, we.
slightly escape me, but certainly I think in this case we can just say, well, we've got the list of bondholders by number,
Yes.
so it would at least be useful to know who's who in so far as it is said
Yes.
that, for example, certain people were voting with some other interests, or these are the ones who are voting with
Yes.
no other interest or whatever. Now, I'm not sure necessarily this case is going to come down to that, but if we are going to get into it, certainly speaking for myself, I haven't managed to get through
Yes.
through the detail.
I mean, we will certainly we'll provide your lordships in conjunction with the other side with as much information as we can. I mean, my primary submission, as I've already made, is it doesn't provide an answer, because if I'm right on my other submissions that in this case there is no proper reason for departing from pari passu distribution, then I submit that the fact that you've got a majority, which is less than the statutory majority, can't itself supply that reason. And it goes back to the point I've just made a moment ago, which is that if that was right, you're effectively rewriting the statute to substitute, in this case, 62% for 75%, because you're saying, well, no matter how unfair the plan is, no matter how unfair I objectively, the court, think the plan is, I'm still going to go with the majority vote. And in our submission, that can't be an answer.
But I haven't quite understood whether that's because you say the honest and rational person test just doesn't apply at all in those circumstances.
Well, it doesn't do the work of deciding whether a restructuring plan is in the context of cross-class Cramden, where the court needs to look itself at whether the allocation of benefits under the plan is fair. I mean, I'm not saying, as I've made clear, I'm not saying you don't apply it and it's relevant to the assenting class.
No, but you say in the dissenting class,
Yeah.
where ex hypothesised 60-something%
Yeah.
have said we're happy with this,
Yeah.
but you're inviting the court to say, nevertheless, I'm not going to approve it.
Yes.
Is that because those 62% or whoever it is may have been honest and rational, but so what?
Yes.
Or is it because the court concludes that had they been acting rationally, they wouldn't have done it at all? So
It's the former. The honest and rational person test doesn't supply the answer in this context. Let me put another example. I mean, let's assume.
Assuming sorry, do you assume in that they have been properly consulted?
I do. Well, yeah, that's another point which will. I mean, there is also the point we make about the explanatory statement and so on. But yes, I mean that's assuming that.
But to take my lord's point, if the explanatory statement said in big capital letters and red ink, this involves a departure from the pari passu principle.
There is no good reason.
There's no good reason for that, and 62% of non-cross-holding. In fact, it's 65% of the non-cross-holding and 62% when you take into account cross-holdings, I think. But something over 50% of the non-assenting class say, even though we've had a big, drawn to our attention that it's not what in accordance with pari passu, and there's no good reason for that, other than that it will benefit others, not us.
Yes.
We nevertheless vote in favour. Are you saying that the court can't take account of that? And you say
no, I'm not saying the court can't take account of that. But I'm not saying it's an irrelevant factor. But ultimately, what I'm saying is it can't. If the court comes to the view that actually, objectively, the plan is just unfair because there isn't a good reason for departure from the pari passu rule, the fact that you've got that vote, which is less than the statutory majority, doesn't override that. It's not irrelevant. And can I just give you an example, perhaps as a point, just to test the hypothesis? I mean, let's assume you have a dissenting class where 45% vote in favour, but 55% vote against. Now, let's assume they're all properly informed and consulted. I mean, you might say, well, look.
Some honest people who voted for
yes.
it. Yes.
So why does it matter on the majority?
Yeah, you just say you didn't get 75%.
Yeah.
That's it.
Yeah.
And Parliament set the 75%, and you can't.
Exactly, and you can't massage away the 75%. I mean, our submission on the way the legislation works is essentially if you don't hit the 75%, then effectively it becomes the role of the court to decide between the assenting and the dissenting class as to what should happen in relation to the plan and whether the plan's fair.
It does slightly go back to the question of whether the fairness is any more than you're not going to be any worse off. In other words, whether you have the horizontal comparison as well. Because you might well have a rational person saying, I've got 100,000 in debt. I concede that if I don't approve this, the likelihood is it will go into insolvency. I'll get 63%, I'm told. I think I'll be better off voting for this, even though I know that I'm taking more risk than other classes.
Yes.
That would be a rational thing to do. But in your submission, it still wouldn't be a fair thing to do.
But equally, it would be rational to say no.
Well, yes. Yes.
Well, provided that the court, you say, should back that, provided that you can see that there is an alternative which remedies the unfairness. I mean, if you actually couldn't see how to remedy the unfairness.
Well, I mean, that's a completely different case then. I mean, I quite accept that if there isn't a realistic alternative, then
and I'm not by there suggesting. I mean, it is said, I think, against you. This was, the only deal which commanded the sufficient agreement of the majority of creditors. And you say, well, that's just saying. Well, they would say that, wouldn't they?
And that's the point Mr. Justice Zaccaroli rightly poured cold water on in paragraphs 37 and 38 of House, because he says, well, that's not a very good point, because you could always do the plan treating us as the assenting class and use us to cram down the others. So if that was the answer, it sort of opens the door to doing what you want under these things. We've covered a lot of ground on ground 2. Just paragraph 22, Maleficent skeleton. I mean, again, we say that quite some care needs to be taken with these citations again. I mean, we've looked at amicus. We've looked at prezzo. And again, they make the same error here, I'm afraid, because paragraph 56 is part of Prezzo that is dealing with the analysis under the ordinary scheme principles before the judge goes on at paragraph 58 to deal with the points that are specific to cross-class cram-down. And he, in Prezzo, places no reliance on the satisfaction of the honest and intelligent person test in that context. And I've already showed you paragraph 68 of Prezzo. And likewise, the reference in List Track Midco is wrong because those paragraphs are dealing with the 4 plans where cross-class cram-down was not sought to be relied on because there wasn't a dissenting class. So that's ground 2. The third ground is that is that to the extent the judge said that the plan did not involve a departure from the pari passu principle, then in our submission he was wrong. Now this point arises in relation to paragraph 298 of the judgment. And this is page 898 of Core Bundle 2. And what he says in 298, in my judgment, the plan does not involve a departure from the pari passu principle because it will preserve the existing maturity dates of the sons apart from the 2024 note. And then I found that if the plan is implemented, it's likely that the plan creditors will be paid in full. Now I'm going to come and deal in a moment with the second sentence. The first sentence in our submission is simply wrong and with respect demonstrates a misunderstanding on the part of the judge. In our submission, the plan involved a departure from the pari passu principle precisely because of the different maturity dates. And that's because, as I've already explained, in the relevant alternative of formal insolvency, all of the sons would have been accelerated and would have ranked for payment pari passu, and they would have shared the risk of the assets not being sufficient to meet the liabilities equally, but because under the plan they have differing maturity dates, a different debt bears different risks of the assets not being able to meet the liabilities. So that sentence in 298 puts it, with respect to the judge, completely the wrong way round. It's because the plan replicates the existing maturity dates that it deviates from the pari passu rule. And indeed, when you get to 301, on the next page, at the top of page 899 of the bundle,
I see entirely why you say that he gets it the wrong way around, but maybe that's just a misreading. Maybe all he's saying is, in my judgment, the fact that it will preserve the existing maturity dates does not entail that there will be a departure from the pari passu principle. The reason there won't be a departure is because on my findings it's likely it won't be paid in full.
Well, in my submission, that involves, I think, sort of reordering the grammar of those two sentences. I will deal with that point because in my submission that's not what he actually found when you look at the other parts of his judgment. I mean, if your lordships read it in that way, then so be it. But insofar as he was suggesting that the plan doesn't involve a departure from the pari passu principle because it preserves the existing maturity dates, then that is wrong. And indeed, I mean, I'm not sure it is a slip, because if you go to 3021, he makes a similar point, which in our submission is also wrong. And he says in 3021, the plan preserves the existing maturity dates of the sons apart from the 2024 note. This reflects the commercial risks which the 2029 plan creditors assumed when they purchased them. Well, in my submission, that's wrong. I mean, the 2029 note holders, when they purchased the notes, would have assumed that in an insolvency they'd rank pari passu.
Well, no, I think you're reading too much into that, because the next sentence, I'm not satisfied the plan involves a significant change to the balance of those risks. What he appears to be saying is when you buy notes with different maturity dates, you accept risk because of the different dates of maturity.
Yes.
What he's not going on to ask himself is, what risks am I talking about?
Yes.
The risk is failure, default. What he's not going on to say is, and in a default, they would be accelerated and would rank
pari passu.
pari passu.
Yes, exactly. Well,
But going back to my Lord's question to you, later in 298, the sentence does appear, I might well have been prepared to accept that the plan involved a departure from the pari passu principle if I had accepted the AHG's evidence and found the most likely outcome was a significant shortfall, even if the plan was fully implemented. So it is possible that all he was actually intending to say was that because he's found it's likely you'll be paid in full, there's no departure from the pari passu principle.
Well,
I know you say that itself is wrong. But,
you constrain to. It's not in fact what it says, but you can strain to read it in that way. And I'll come to the question of payment in full and what the judge in fact did in relation to that in a moment. But I think all I need to submit on 298 is if you read it literally, and your lordships may or may not be inclined to do so, then it's wrong. On 3021, accepting my Lord Justice Snowden's point, let's say the judge is referring to the commercial risks inherent in a going concern of the planned company. In my submission, then that simply misses the point, which is that in the relevant alternative here of a liquidation, they all share the risks equally, which is the risk of the assets not being sufficient to meet the liabilities, whereas under the plan they don't, and the plan does involve a significant change to those risks. Yeah. So, if you read it that way, then it simply misses the point. It was misdirected.
Different maturity dates are not a risk. The different maturity dates are just what you bargain for. You just bargain for something to be repaid to you on a certain date. That's not a risk. The risk is that the company fails within the period of time over which your loan is outstanding.
Yes.
And so, to some extent, the longer your loan is outstanding, the greater the risk.
That's right.
But the risk is of failure.
Yes, exactly. So, you obviously bear a longer credit risk by having notes with a longer date of maturity, because there's a longer period of time during which the company may fail. But what you also know is if at any point during that period the company does fail and become insolvent, at that moment in time, you will be treated pari passu with everyone else who has outstanding debt. And what the plan is doing is involving a very significant change to that commercial expectation and understanding. So, I'm content to just put it on the basis that 302 subparagraph 1 is misdirected in terms of what the actual issues were in this case. So far as the point about payment, just taking stock there. Everything I've said in my submission so far, I respectfully submit holds good, even if you take the judge's second sentence in 298 as being correct. Because as he himself accepted in 301, at the top of the next page, even if 298 is right, and the way he's articulated it in 298 is right, it's still right that the plan involves a greater risk than the 2029 plan creditors.
Because that's what pari passu is all about.
Exactly. So ultimately, my primary submission is it doesn't actually matter whether the second sentence of 298 is right or wrong, because I rely on what he says in 301, what the judge himself said there. But in our submission, the way he's put it in the second sentence of 298 doesn't actually accurately summarise the exercise which he's undertaken in the judgment. Now, if I can just explain that point to you, it'll take a little bit of unpacking. You need to go back to paragraph 212 of the judgment. And in particular 212 and 213, where the judge begins by explaining his approach to the factual issue, which he describes as a complex factual issue, of what would be likely to happen in the relevant alternative. And he says, I accept the submission that there is inherent uncertainty in the projection of future property prices, and the court must take this into account in deciding whether or not to sanction the plan. In the Virgin Active, Mr. Justice Snowden states that the first stage of the test, the court is not required to satisfy itself that a particular alternative would definitely occur. And that if 3 possible alternatives are presented by the parties, the court is required only to select the one that is more likely to occur than the other 2. Now, that reflects what my Lord said in Virgin Active, and your Lordships will have that in, I think your Lordships have it in Authorities Bundle 2. At divider 28, and it's paragraph 106 to 108, which is at 884 to 885. Now, without wishing to put words in the mouth of my Lord, I mean, what my Lord was dealing with there was what was described as the first stage of the no worse off test, which, as described in the opening sentence of 106, is to identify what would be most likely to occur to the plan companies if the plans were not sanctioned. So in other words, it's the factual question of what would be most likely to occur. And what my Lord said in 107 is this. It's important to appreciate that under the first stage of this approach, the court is not required to satisfy itself that a particular alternative would definitely occur, nor is the court required to conclude that it's more likely than not that a particular alternative outcome would occur. The critical words in the section are what is most likely to occur. Thus, if there are 3 possible alternatives, the court's required only to select the one that is more likely to occur than the other 2. So in effect, what this presupposes is you don't actually ask yourself what would be likely to occur. You look at the options that are put before the court as if they were a menu, and you select which of those is the most likely. Now, and then that's the approach which the judge identifies in paragraph 212 of the judgment. So in effect, you identify the relevant options and you pick the most likely one.
That's because that's what the statute says.
Yeah, I'm not saying it's, to be clear, I'm not saying this is wrong. I'm just explaining what approach the judge has actually done, because it's then relevant to what he actually finds. And if you go back to 213, what he says is that in the present case, however, the principal issue between the parties was not about the first and second stages of the test, i.e. what the relevant alternative was and what its consequences might be for the 2029 creditors, but about the third stage, namely what the outcome would be for the 2029 plan creditors if the plan was sanctioned. But I see no reason why, in principle, the court should not adopt the same test at the third stage as it does at the first stage. Indeed, it may be implicit in the comparison at the first stage of the test. And then this, I do not have to be satisfied, therefore, that the 2029 plan creditors would definitely be paid in full if the plan was sanctioned, but merely that this is the most likely of the alternatives presented to the court. And in doing that, he's effectively taking the Virgin Active approach and applying it to the third stage of the test. Now, what that, in our submission, is critical, because what the judge...
Is that wrong?
I'm not saying it's wrong, but no, the question is, what he then says he found in 298 doesn't reflect the actual exercise he's doing as described in 213. I'm not saying what he's described in 213 is wrong, but there is a very subtle but important difference between finding that plan creditors will be paid in full under the plan and finding that the most likely of the scenarios presented to the court is that plan creditors will be paid in full under the plan. Now, let's just assume that you have a situation where two alternative scenarios are put before the court as to the financial outcome under the plan. Under the first alternative, 2029 sons would be paid in full, and let's assume that has a 30% probability of occurring. Under the second alternative scenario, the 2029 sons will receive 50 cents in the euro, and that has a 20% probability of occurring. Now, the most likely scenario of those put before the court is that the 2029 sons will be paid in full. But that is rather different from a finding that they will be or are likely to be paid in full. And the fact that the court picks from the options put before it as to what it thinks is the most likely of those options isn't the same as a finding, an absolute finding, that it's likely that the notes will be paid in full under the plan. And the reason is there's obviously a myriad of there's probably myriad other options of possibilities in addition to those that are presented to the court. I mean, possibly countless. I mean, one could think of all the different variations you might have as to what might or might not happen under the restructuring plans. You could probably put 1,000 different scenarios before the court. But it is a very subtle but very important difference. And it's in our submission, it's undoubtedly clear what approach the judge has in fact applied. And if you go, we'll come back to some of the other references, but the other core bit of his analysis on this point is 291 through to 293. Where he effectively, in these paragraphs, ties together his conclusions on the no worse off test. And he makes some points in 291, including in the final sentence, accepts it will be ambitious for the plan company to pay off the 2029 creditors in full. Then he says in 292, nevertheless, it's important to have in mind the statutory test which the court must apply. I have to be satisfied that the 2029 plan creditors will be no worse off than they would in the relevant alternative. It's not necessary, therefore, for the court to be satisfied that the most likely outcome is that the 2029 plan creditors will be paid in full, only that the most likely outcome is that they will be better off. And then he says, I'm fully satisfied that this is the most likely outcome, because even if the group fails to achieve the sales price forecast by BCG and is only able to recover the sums forecast in the Knight Frank report, I'm still satisfied that the 2029 plan creditors will be better off. That's a consequence of my finding on the plan company's alternative case. Now that's what's referred to as the alternative enforcement scenario, or sometimes the Luxembourg enforcement scenario. That doesn't involve the plan creditors being paid in full under that scenario. So one can then move on from 292. And then 293, he then says this: if I am required, however, to choose between the alternatives put forward by the parties, like choosing from a menu, then I find the most likely outcome is that the 2029 plan creditors will be paid in full, and for the reasons I've given, I consider the least likely outcome to be the one put forward by the AHG. And 293 reflects the exercise which he's identified, he's undertaking earlier in the judgment at 212 and 213. So in our submission, what he's done, in fact, is to look at the different financial outcomes presented to him and said, if I'm like picking from a menu, I think that one's the most likely, I think that one's the least likely, and then there's presumably one in the middle as well, because there was 3 scenarios put to him. Now, in our submission, that is a somewhat different exercise to deciding that the 2029 sons will or are likely to be paid in full under the plan. Because on his analysis, it may be the case that the 2029, the probability of the 2029 credits to be paid in full is less than 50%, but it's still the most likely of the 3 options put to him. And in our submission, when you get to the statement you see in 298, which we were looking at in the second sentence, where he says, "I found that if the plan is implemented, it's likely that the plan creditors will be paid in full." That doesn't really reflect the actual exercise which he's done. What he's found is the most likely of the scenarios presented to the court is that the plan creditors will be paid in full. That's a subtly but rather different thing, if one follows. And in my submission, I mean, once you look at the actual logic of his reasoning, it's quite clear what he's done. Now,
So, just to try and figure this out,
yes,
if there are three possibilities
yeah,
in the absence of the plan, to which experts ascribe a 35%, a 35%, and a 30% likelihood. In other words, as I would understand it, the total, if there are three possibilities, the total should add up to 100 because those are the only three alternatives, or is that wrong?
I'm not sure it necessarily has to add up to 100, does it? I'm not sure.
Well, unless there's some other...
well, let's assume.
there are three
Yes.
possibilities.
Yeah, so you're assuming that
So-
the three
so-
possibilities is the total population of possibilities.
Yes, because I mean, you know, everybody's looked at this and everybody's agreed there are only three possibilities.
If that's the premise.
So,
yes.
35%, 35%, 30%.
Yeah.
Let's say. Oh, sorry, that's making it too difficult. Choose some other numbers for me, please, somebody. But let's go with those for a second. 35%, 35%, and 30%.
Yeah. Well, each of those is less than 50. So.
Yeah. In which case you'd say that the most likely is one of the 35. So you have to figure out some other way which is most likely. But it doesn't mean, is that right, that it's more likely than not to happen? Or am I just getting... Can somebody who's good at probability and statistics help me out?
Well, I mean,
is there an error there in that logic?
No, I don't think there is. I mean, I think let's take a different set of figures. I mean, maybe makes life a little easier. I mean, let's say there's three possibilities, and we'll work on the premise for the moment that those three possibilities is the total population of possibilities. And let's assume one has 36%, one has 34%, one has 30%.
Yeah, okay.
And that adds up to 100. So the most likely of those is the first one. And that is essentially what the judge in my submission 40 was doing. It's essentially sort of ranking them in order of likelihood and picking the most likely. But that doesn't mean that looked at...
That it's more likely than not to happen.
Exactly.
Because in fact, it's less than 50%. Is that the...
Exactly, yes.
But do we have three options in this case?
We did have three options because we had the plan company's primary case, which is payment in full under the plan, which was the BCG report. We had our case, which is that actually we'd get, I think, 10.6% under the plan based on the property prices. And then what appeared in the run-up to the hearing was what's called the plan company's alternative case, where they said, well, even if property prices are less than we think, what will happen then is a default, and there'll be this enforcement scenario. And if that happens, I think on their figures we'd get 63%. So there was the three possibilities. And what the judge said, and if you go back to the critical bit of the judgment at 292, 293, what he said in 292 is, well, I think the 2029s won't be any worse off. And that's the reason, and that's effectively because of combined reasoning that either the plan company hits the figures in the BCG report, or if it doesn't, there'll be this alternative enforcement scenario. And he says that's enough for me to conclude that the no worse off test is met. And then 293, he sort of goes on as a bit, I mean, I think he thinks this is probably not necessary for his conclusions on the no worse off test. But he says if I have to choose between the alternatives put forward, like choosing from a menu, then I think the most likely one is the payment in full, and the least likely one is ours, and I infer that the one in the middle is the alternative enforcement scenario. As I say, I mean, that doesn't mean, it doesn't follow from that the payment in full option has a probability of over 50%. Not at all. And,
Well,
and indeed,
I'm not entirely sure. I don't find 291 to 293 entirely easy, but this is where he's dealing with condition A.
he is, yes.
Condition A requires him to be satisfied, and that presumably means satisfied on the balance of probabilities, and the onus being on the proponents of the plan, that the members of a dissenting class would not be worse off than in the event of the relevant alternative. So that does require, that's a binary choice. You have to say, do I think on the balance of probabilities they're going to do better than the relevant alternative or not? So it's a yes-no question.
Yes, and he answers.
There's only really two answers to that.
Correct, but he answers that.
So that is at 50%.
No, but he answers that, yes. I mean, indeed, he answers that in 292, but he answers that by reference to a combination of the plan company's primary case and the alternative Luxembourg enforcement scenario. And effectively what he's saying in 292 is, well, I mean, either you get the returns as projected by the plan company, or if that's wrong, then the alternative enforcement scenario will apply, and you'll still do better than the liquidation under that. And taking those points together, I can conclude that the no worse off test is met. That's what he's doing in 292. And then 293 is effectively an addition. He then says, well, he's effectively saying, well, that's enough to get me home on the no worse off test. And then if, however, I'm actually required to pick which of them is the most likely, then I opt for the payment in full. As I say, I mean, if you're picking from a menu of 3 options, which, by the way, may not be the total number of options anyway, it doesn't mean that the one you pick has a 50% probability or more.
But he does need to conclude that there is a 50% probability.
Yes.
That, at any rate, the dissenting class, the 2029 creditors, will get more under the plan than they would in an insolvency.
Yeah, be no worse off is the test. So he has to be. So that's what he does in 292, because he concludes. I mean, you have to read 292. I'm fully satisfied that this is the most likely outcome, i.e., that they will be better off, because even if the group fails to achieve the sales prices forecast by BCG in the BCG report and is only able to recover the subs forecast in the Knight Frank report, I'm still satisfied that the 2029 creditors will be better off.
I think Mr. Bayfield wants to interrupt.
Well, could I just, so that the debate isn't held on a slightly skewed basis, ask my lords to read paragraph 290, which is the paragraph before this section. It may assist at least to shed some light on this.
Yes, I mean, there's a number of... Yes, I mean, I agree. I was actually going to refer to 288 and 290, because he says there in 288, the group is more likely to realise the sums in the BCG report than the sums in the Knight Frank report. And then 290, he says the same, and then you get this, therefore, that the plan creditors will be repaid in full. But you have to look at what he actually decides in 293, which is that what he's actually doing is picking the alternatives from the menu, which is the exercise he has identified.
But 293 is fairly plainly put forward as an alternative, it's a sort of fallback case.
Yes.
So that's not what he's doing in 292. Well, what we haven't looked at is his actual finding, which is at 217.
Yes.
He prefers the evidence of Mr. Wolfe to the evidence of Mr. Gerlinger, and you can't and don't seek to go behind that. That was a matter for
Yes.
him. He finds on a balance of probabilities
Yes.
that if the plan is implemented, the group is more likely to realise the BCG sums than the Knight Frank sums. But then it's the next bit. And that it is likely that they will be repaid in full. Now, reading it by itself, that looks like a finding on the balance of probabilities.
It does, but you, I mean,
not 34% or 36%, but over 50%.
Well, yes, but I need to take you through all the other references in the judgment where he's put it in terms of the most likely outcome being that they will be paid in full. And in my submission, I mean, you have to look surely at the test he has identified, which he himself has set out in 212 to 213.
So your submission is all he's really decided is that he thinks BCG is more likely to be achieved than Knight Frank.
Yes, and indeed, I mean, if you look at 217, it doesn't actually make internal sense, because the fact that the sums forecast in the BCG report are more likely than the sums in the Knight Frank report doesn't mean that it's likely that the 2029 creditors will be paid in full. It just means that scenario is more likely than that one. It doesn't follow.
No,
Yeah.
it reads as two separate findings.
Well,
on the one hand, I prefer Mr. Wolfe to Mr. Gerlinger and BCG figures to Knight Frank figures, and I go on to find that it's likely they'll be paid in full. And
well, I mean, yes, I mean, it's not a. I mean, in places, it's not a particularly easy judgment. It has to be said, but I mean, the way in my submission you have to look at this is look at what he has identified himself as being the correct approach in 212, 213, and then look at what he's actually decided. It seems to us in 292 and 293, and 293 is the one explicitly where he puts it in terms of picking from a menu. And
I mean, if you, I mean, you get this all the time in valuation cases. I mean, each side puts up their own valuer, and valuer one says it's going to be 10 million, and valuer two says it's going to be 8 or something. Judge's got to decide which he thinks is more likely. But now, once he chooses between the two, although in a way it starts out as a comparative exercise, and you can put it as you're doing in terms of one being more likely than the other, what the judge ends up doing is finding on the balance of probabilities that the 10 million figure is right.
well,
I mean, you can't discount that, can you?
well, in my submission, that's not the exercise he thought he was doing, and in my submission, that's not the exercise he was doing, because he was presented with a number of scenarios. 3. I mean, there may have been others as well. I mean, it's quite possible to come up with any other number of sort of intermediate scenarios as to what the outcome would be, and he's effectively ranked them in order of preference. And can I just show you also what he, whilst we're on this point, before I weary your lordships too much with it, just what the judge himself said on the permission to appeal hearing in the transcript about what he thought he was doing. If you go to the supplementary bundle at tab 12, and it's page 26, page 323 of the transcript. And you see,
sorry, give me the reference.
it's page 323 of the bundle, it's page 26 of the transcript. Now, it begins at the top of the page with a point I was putting to him, which is essentially what I thought he was doing in 292 of the judgment, and that's the first 5 lines on page 26. And then he says this: what I decided was that the most likely alternative, if I had to pick one, was paid in full. The next most likely alternative was there was default and inaudible treated pari passu, and that's the alternative enforcement scenario. Then the third and least likely as the alternative was the one where you would just do nothing and you'd get 10.6%. But I then reminded myself that the overall test, which I had to be satisfied, was that the plan companies demonstrated not that you would be paid in full, but that you would be no worse off, and I was satisfied with. That reflects 292. But in our submission, I mean, clearly what he thought he was doing was effectively the ranking exercise that was described in Virgin Active. He's picking them in order of preference, as if they were on a menu.
Can I put a rather different point?
Yeah.
The way that litigation works, civil litigation, is that if it's a question whether something happened or not in the past, we decide that on the balance of probabilities.
Yes.
It doesn't matter whether you're 100% convinced it happened, or
Yeah.
you're only narrowly persuaded that on the balance of probability it
Yeah.
happened. For the purposes of a judgment, it's then treated as if it happened. It's a finding.
Yes.
But you can't find in the same way what's going to happen.
Quite.
You can't prove what's going to happen. All you can do is prove what's likely to happen. Now you have to be, for the purposes of condition A, there's a binary test, no worse off or not. You have to come to a view on that.
Yes. But this, to be clear, I mean, I'm not challenging him on condition A. Where this point is relevant for present.
The question is whether you're taking on any risk.
Yes.
And the mere fact that he's decided it's more likely, even if he had decided that on the balance of probabilities he thought it was likely you'd be paid in full, doesn't mean you're guaranteed. As he himself says.
I agree.
It doesn't mean you're guaranteed to be paid in full.
Just be careful not to kick that particular gift horse in the mouth. That point is in your favour.
I know, exactly. That's why I'm saying. That is our primary point on this, and that's why I say the second sentence of 298 ultimately doesn't matter, because I hang my case on exactly the point my lord has put to me. And indeed, it's not just 301. It's where he says in 291. If I can just show you that.
But to put the point a slightly different way, if the Lord's right and you agree with him, why are we dancing on the head of a pin about this other preliminary point?
Well, because it is one of the points that's put against me, and I although it's my fallback, if you like, I don't accept that when you look at what the judge actually did, that he did in fact find that plan creditors would likely be paid in full under the plan.
I mean, your point is that, as indeed he recorded at 301, I mean, pari passu as a principle would only be irrelevant to your clients if there was an assurance that they would be paid.
Yes, exactly.
I mean, that's really the way it's put.
That's our primary way of putting the case, and I quite accept this point we're on, which is you might think is a diversion, only arises as effectively on an alternative case for me. But it's just I don't accept. To be clear that my lord friend is right to characterise the judge's findings. Just whilst we're on the risk point, the other point I wanted to just draw to your attention, which is in the same vein, is what the judge said in 291 in the final sentence. And he says, I accept it will be ambitious
Yes.
for the plan company to pay off the 2029 creditors in full.
Well, but that's the same as saying, in a sense, paragraph 300, last sentence. Oh, sorry, paragraph 300, there's two sentences, one in the middle
Yes.
of it. I cannot be certain that the 2029 plan creditors will be paid on full, or even that they will recover on a pari passu basis if the plan company defaults. Whilst I was satisfied that this was a likely outcome, it remains far from certain.
Yes, and then exactly 301. So I mean, all of that is part of a theme.
Right. So,
Yes, as I say, I mean, I think I've made it clear that our primary case simply rests on the premise that you can treat 298's second sentence as being correct, and all the points I've made remain good because of the risk, the lack of certainty, the ambition in the possibility of repayment. But I don't accept, for the reasons I've explained, that 298's second sentence does in fact accurately reflect the exercise which the judge was himself doing.
Can I be sure I've understood, I've got this right? If you look at the comparator report in the supplemental bundle at page 34,
Yes.
there's a chart which, as I've understood it, compares what you get according to BCG under the relevant alternative and what you get under the management plan. And in the
Yes.
roughly the middle of the page, there's a minus 0.4 excess cash.
Oh yes.
Is that the ultimate surplus that on this plan is over and above what's needed to pay you in full?
Yes. So that's the I mean, it's sometimes referred to as the headroom. It's the,
The
service
headroom.
that go to creditors.
And I think there was some evidence that they adjusted it downwards.
They did, and it went down, I think, to, just bear with me.
By 0.3.
Your lordship's exactly right. I think it went down to 309 million from recollection, 309 million euros. I think it had started at, so it started at 403 million euros, and then it went down to 309 million euros.
So the judge could perfectly rationally have said, well, I think this is what is the most likely thing to happen. But still, there's obviously that if figures are only not very many percentage points off, you lose the whole of the headroom.
Yes, exactly. It only needed to be a tiny point, tiny amount off to for the headroom to evaporate. And all of this, I mean, you will have,
at which point the entire risk falls on
Exactly.
it falls on you first.
Yes, and your lordships will have appreciated. I mean, all of this projection was essentially based on BCG estimating how various macroeconomic factors in Germany would turn out over the next 6 years. So they had to sort of estimate what interest rates would be, what inflation would be. It's all. I mean, it's essentially a model, and no doubt they did the best they could. But I mean, the idea that it's any guide, certainly not a guarantee, but I mean, query how reliable, even as a guide as to what might be paid in 2029, is questionable. And that's why, as I say, I mean, I think I've made my position clear. I mean, we fundamentally rely on what the judge himself said in 291 last sentence, 300 and 301. It's just I don't, for the reasons I've explained, as a fallback, accept the correctness of the articulation in 298 second sentence. But even if I'm wrong about that, it doesn't affect my primary case. I think that is all I need to say on ground 3. Ground 4, we've in fact covered a lot of the ground on this because it really is the sort of conclusion of what has gone before. And this is that we say the judge shouldn't have sanctioned the plan, which involved a material divergence from the pari passu treatment and the relevant alternative in circumstances where there was no proper reason or justification for that divergence.
I mean, the other divergence that you haven't mentioned, at least not in this last few minutes, is the grant of security.
Yeah, I'm coming to that exactly. So,
sorry, you're only dealing at the moment with the.
maturity date.
Maturity date.
Yes, I'm going to come to the grant of the secured. I was going to deal with them in a similar way to the judge dealt with them by dealing with them in turn. I mean, just in terms of general approach, I mean, in our submission, the judge actually put the point correctly in paragraph 74 in the final sentence. And this is page 784 of the judgment. However, even if there are differences in the treatment of individual creditors or class of creditors, the court may still approve or sanction the scheme, provided that there is a good reason or proper basis for departing from the pari passu principle and for the differential treatment. We don't disagree with that as a statement of principle, but where the judge fell into error is failing to apply and follow that guidance, since there was no good reason or proper basis for the departures from the pari passu principle. I've already dealt with the ways in which the plan diverged from pari passu. The two significant ones are the maturity dates different coming out of the plan, and also the grant of priority security to the 2024 sons over the security given to the other sons. Now, just dealing with the maturity dates first, what we respectfully say is remarkable about the judgment is that it's clear on the evidence that there was no good reason for the different maturity dates under the plan. And indeed, the judge accepted this, but he nonetheless sanctioned the plan. And that was despite what he had said himself earlier in paragraph 74 of the judgment. And as I've already explained, the reason why there was no good reason for the different maturity dates was that it would have been perfectly possible to construct a wind-down plan which achieved the objective of a managed wind-down while also preserving the pari passu treatment. You simply provide that any recoveries as and when they're made are shared pari passu. That was conceded rightly by the plan company in cross-examination. If your lordships go to tab 11 of, I think this is in the supplementary bundle, you have the cross-examination of Mr. Trotsey, who was the director of the company who was put up to give evidence. And if you go to 291, I dealt with this point with him at the bottom of page 30, line 24. Let's turn to the different maturity dates being given to the sons under the plan now. For these purposes, could you please go to paragraph 190 of your first witness statement? And then you can see I effectively put to him what is said to be key objectives of the plan to give time to realise asset disposals without being subject to fire sale or insolvency discounts. And then line 17, I say this point could simply have been dealt with by providing for the rateable payment of all the son's realisations as and when they were made, couldn't it? And then he initially doesn't want really to say yes. It says potentially. The answer is yes, isn't it? Yes. Why wasn't it done that way? And then he explained why it wasn't done, and essentially that's not what the AHG wanted.
Sorry.
What's the AG?
That's the Ad Hoc Group. So when he says by the AG, I think that should...
It's not your client?
No, it's not Aiken Gump, certainly not. It's the Ad Hoc Group, so it's essentially referred to otherwise as...
I think you became the Ad Hoc Group.
I think Mr. Trotsey referred to them as the Ad Hoc Group or AG, but actually he's referring to the SteerCo.
Is that right? What he says is that the terms of a transaction put forward by the AG did not have sufficient support. I read that as meaning the AG is you.
Yes, I'm sorry, your lordship's absolutely right. It is. That must be, when he says the AG, I think that is Aiken Gump, because if you go on to the if you go on to the next question, I mean, I put to him this was something that was dictated to the company, was it by the SteerCo? And then he goes on to say, use the term dictated. I would say this was part of the negotiations between the company and the vast majority of its lenders and the SteerCo. All
right, so at some point your clients have put forward...
We'd put forward a proposal that was rejected. And then he goes on, and I think it's really lines 3 to 9. I say, well, so this is something that was dictated to the company, was it by the SteerCo? Use the term dictated. I would say this was part of the negotiations between the company and the vast majority of its lenders and the SteerCo, providing the restructuring plan that would be supported by the sons. And then I say, why don't you mention in paragraph 98 that this probably could have been dealt with simply by providing for rateable payment of the sons from the realisations as and when they were made. There's no specific reason. I think I do refer in my witness statement to the AG, so that is Aiken Gump's proposed transaction, and comment on it. So the important point that really matters, I mean, in essence, the reason why the plan company ended up where it did is of less relevance than the fact that he accepts rightly, and this is obviously right, that it could have been done, the objectives could have been achieved by respecting the pari passu treaty.
So if everybody had been happy, there would have been no other objection to doing it that way.
Correct.
Yeah.
Exactly right.
So I mean that's the proposition that you can depart from the pari passu rule by a scheme, albeit that the court would normally ask why.
Yes, and this is a good reason. Yes, exactly. And that bit of evidence, I mean, he very fairly, he didn't try to run from the point. It's obviously right when you think of the logic of what the plan was trying to do and how it would have done it.
Was anything said to creditors in the explanatory statement about the fact that the plan was not following the pari passu rule that would apply in an insolvency? We don't have the full explanatory
We don't.
statement.
I mean, let me check that. For recollection, it wasn't a point that was put full and centre. Let me check what we can get from that.
I mean, but presumably, that if something had been said to creditors, the judge presumably would have had his attention drawn to it and would have said something about it.
Yes,
But he didn't.
about the reason why it was departing from the pari passu rule.
Yeah.
Yes. No, I don't think the explanatory statement descended into the reasons why they were doing it that way rather than another way. But I'll be corrected if I'm wrong about that. So that evidence, I mean, that is crucial in our submission when it comes to the looking at the unfairness of what was put forward. You also get what the judge himself said in 302 sub 7 at the bottom of page 900 of the bundle. And this is the second sentence of 3027, bottom of the page. Despite the volume of evidence filed by the parties, I was not given a compelling reason why the plan companies wish to preserve the maturity dates and not to agree to harmonise them at the outset. And indeed, bear with me. So, I mean, it's quite clear that there wasn't a proper reason or good justification for the differential treatment. I mean, even now, the plan company doesn't put one forward. I mean, it doesn't even attempt to provide such a reason in its skeleton argument on this appeal. And there is no respondent's notice on this point saying, actually, there is a really good reason why we had to depart from pari passu. Now, in the respondent's skeleton, they say there's 4 reasons why the judge was satisfied that the difference in maturity dates wasn't a bar sanctioning the plan. And they deal with these in their skeleton at paragraph 30 onwards, page 985 of the bundle behind divider 10. Now, at the outset, I'd ask the court to note that none of these points are in fact a reason or justification for the differential treatment, in the sense that none of them even seeks to explain why the differential treatment was necessary in order to achieve the objectives of the plan. None of the reasons actually engages or addresses that point at all. What they do instead is make a number of different points, and these reflect some of the ground we've covered already. First, they say that the judge relied on his finding of fact that the most likely outcome under the plan is that all 6 series of sums will be paid in full. Well, with respect, that doesn't address our point, which is that on the judge's own findings, there's risk, there's uncertainty, there's ambition involved in repayment in full. Even if you take the judge's conclusion as being the one in the second sentence of 298, that isn't the point we're concerned with here. It's about allocation of risk. Second, and then paragraph 31 essentially just deals with the debate we've been having about what the judge did in fact find in terms of likelihood of payment in full. I'm not going to go over that again. Your lordships have our submissions on that, including our main submission, but it doesn't actually deal with the point we're making. Paragraph 32 on page 987, they say that the judge held that the plan includes a number of protective provisions which, taken together, reduce the materiality of the different maturity dates. And these points essentially go to what we've described as the alternative enforcement scenario. That's the scenario that the judge dealt with at great length in his judgment, paragraphs 218 to 287. But all that goes to, on the judge's analysis, was to support his conclusions on the satisfaction of the no worse off test in condition A. You saw that in paragraph 292 of the judgment. And that was because he said that even if the property prices were less than the company was predicting, or more like we were predicting, then that would trigger the enforcement scenario. And in that scenario, we'd be no worse off than in the alternative to the plan of a liquidation. But all that demonstrates is that the no worse off test was made. It doesn't itself, as a matter of discretion, provide a reason for departure from pari passu reasoning, pari passu distribution. So that's not a good point. Paragraph 33. Paragraph 33 in our submission is a very bad point. What paragraph 33 says is that there was a good reason for preserving the maturity dates, namely the avoidance of a debt wall in which all the sons fell due at the same time. Now that's a bad point for two reasons. The first is that avoiding the maturity wall didn't and does not require differential treatment. You could have given all the notes the same maturity, but dealt with the issue of a debt wall by simply limiting their rights of recourse to the realisations as and when they were made.
Which is what happens in a liquidation.
Exactly. And indeed, I think I put this point specifically to Mr. Trotsey. Yes, and so for the record, if you go back to the supplemental bundle, tab 11, page 292, page 33 of the transcript, line 12. Again, you could avoid a maturity wall by having all the sons rank equally, but be limited in recourse to a share of any recoveries as and when they were made, couldn't you? Yes. Exactly right. Now, the other reason why this point is actually a bad one is that it's the plan that actually creates a maturity wall. And that's because under the plan, there is a very large amount of debt which will mature in 2025. And I dealt with this with Mr. Trotsey over pages 35 to 37 of that transcript. But essentially, it's actually the plan that makes the position far worse because it creates a maturity wall that falls due in 2025. And I mean, I put this to him. It begins page 35, line 20. And I've made the point in page 35, lines 20 to 22, that the new money has a maturity date in July 2025. And then you have the 2025 sons that have a maturity date of August 2025. And then, as I say, in lines 9 to 12, so just looking at that, there is about, by our calculation, including 2.3 billion of debt, which will be repayable by the group in June through to August 2025. So it's the plan which creates a maturity wall, doesn't it? Because it creates a situation where the group has to repay 2.3 billion euro of debt in 2025. And then he seeks to quibble with that. But then, as I say, 37, in an insolvency proceeding, there is no maturity wall. There is no crunch point. Yes, what you've created under the plan is a maturity wall or crunch point. Roughly the middle of 2025, where 2.3 billion euro of debt will fall due. You accept that, yes. So, I mean, this point is actually a very bad point for the plan company because it's the plan actually makes the position far worse in terms of creating the maturity wall. And then the final point is the point of paragraphs 36 to 37.
Can I just ask, I mean, it'll be for Mr. Bayfield perhaps to answer this, but I did have some problem with paragraph 34 of Mr. Bayfield's skeleton.
Yes.
It's probably right, I should at least say it now so you can think about it overnight, but it says that the bond markets have always attributed materially different prices to the 6 series of sons.
Yes.
So as to reflect their different temporal priorities. Now, what I understand that to mean is that if you assume that in the ordinary course notes will be paid at different times,
Yeah.
they might have different prices.
Yes.
Of course, in the relevant alternative, that wouldn't be the case because they'd all be payable on an accelerated basis. So one would have expected all the notes in an insolvency to have the same value. There would be no, quote, temporal priority.
Correct.
But it said this was the basis on which the plan was negotiated.
Yes.
If the plan was negotiated on the basis that the bonds had different temporal priorities, i.e. they've always been quoted in the markets on a different basis, it sort of doesn't it rather give the game away in the sense that the whole point about this is you're now trying to exercise a cram down power on the basis that in a situation where ex hypothesi, in the relevant alternative, the bonds would all rank
Yes.
together. So that should be your starting point for
You've negotiated on the wrong basis.
negotiating a deviation from the relevant alternative.
Yes. Quite agree. I mean,
You don't have to agree just because I've said it. I've said it so that
well, it's okay.
you've thought about it. But if it is the case that that's the basis on which the plan was put together, then it seems to ignore the fact that the cram down power is exercisable on the footing of a relevant alternative.
Yes.
Which that is where the different temporal priorities would have no existence.
Yes, or indeed put it this way. I mean, let's assume there was a liquidation and all the bonds had been accelerated in that liquidation, then they would all presumably have the same price in the debt market at that point.
That's exactly right.
Yeah.
That's the point. Well, anyway, I've put it out there, so...
Well, I agree. I mean, if they're saying that's... I mean, it's a good point, if I may respectfully say so, because if that's the base on which the plan was...
like all gift horses, if you think it's overnight, it's not such a good point, then don't feel at all inhibited about telling me it's not a good point.
No, well, I mean, it is. I mean, it goes... I mean, I've picked this up in a number of places in the judgment where the judge looks at the position by reference to the contractual maturity date of the debt. That's just not the correct comparison here. The correct comparison is to look at the position in the liquidation where everyone has presently due accelerated debt. They all rank pari passu, they're all in the same boat.
And it's not the comparator when you're... I think arguably it's not the comparator when you're trying to cram down under a regime where the relevant alternative is plainly an important factor, if not the frame of reference.
Yes.
That's the point. Okay.
I'm grateful. And then the final point we'll come back to, and we've already touched on this, is the relevance of the majority. And I'll come back and deal with that separately because that is our, I think that's our ground 5. So, I mean, that gets me to the end of maturity. I've got a little more to say on security, and then I think the remaining grounds I can deal with relatively quickly because we've covered a lot of the territory. I don't know what time your lordship was, whether your lordship's going to go to half 4 or...
Well, how comfortably are we doing?
I mean, I will take. I mean, if your lordship's offering me some more time now, I would take it just to be sure. But
I mean, it sounds to me that you're going to be finished fairly early tomorrow morning.
Well, I think I'll be an hour. I mean,
An hour? Yes.
An hour.
Mr. Bearfield, do you think that would put you under any time pressure?
I suspect not, my lord.
I think we'll draw stumps there. If we're not under any pressure, and we'll see you again at 10:30 in the morning.
Grateful, my lord. Thank you.
Yeah. So yes, please.
Yeah.
Oh, is he down here?
Yeah.
Right, should we go and look up? Thank you ever so much.
Yeah.
See you later on. Okay, thank you.
Oh yeah.
Actually, if you could actually make it really small, let's see that.
Covenant.